Hello, I am professional attorney and very much amateur musician Scott Lesowitz, and in this video I will be discussing why I think Rick Beato's What Makes This Song Great videos are likely fair use, but why there is some reason for some caution. So Rick Beato is a former record producer, songwriter, music professor who now makes music educational videos on YouTube, including the What Makes This Song Great videos, in which he breaks down and analyzes popular songs. And more importantly, Rick has got a great head of hair. In the What Makes This Song Great videos, Rick will play part of the audio of the song that he's analyzing. Now, I've heard Rick say on multiple occasions that he's doubtful that the What Makes This Song Great videos constitute fair use.
In the case of What Makes This Song Great, it's probably not fair use. You know, there are lawyers that said, oh, it's definitely fair use, but I'm using the original sound recording. That is not really fair use, okay? Even though I'm breaking it up.
All right, so how funny and ironic would it be if Rick were to block or place ads on this video because I played a part of his video? All right, I gotta say, as always, I'm not giving legal advice to anybody. Even you, Rick, sorry, I'm not giving you legal advice here. Please don't rely on me, any of you. I know I look really trustworthy because I wear these glasses, but do remember I still am just some schmuck talking on YouTube. And how subjective the fair use test generally is, or usually is, there's also the problem here for when analyzing a situation like Rick Beato's videos, is that because YouTube creators tend to be cautious about getting into copyright fights and risking litigation, there's very little case law to look at. I cannot find anything where a musicologist or musician was using audio from a song while analyzing it. That said, I do want to look at a few cases that I think are important here. There was a case out of the federal trial court in Chicago that found that a documentary's use of 8 seconds of a rap that the 1985 Chicago Bears Super Bowl winning team made and put out was fair use because it was an important part of the historical record for the documentary and for making its points. While using less of the song is better for fair use, even using a few seconds from a song might not be fair use. Think about it this way. You couldn't go cheat on your wife and tell her, oh, it wasn't cheating, it was fair use because I finished in less than 8 seconds. Now I'll talk about a case that I think is helpful to Rick. Then I'll talk about a case that should provide some caution, but I still think these videos are usually going to be fair use. Okay, I apologize for what I assume will be a mispronunciation, but the case is from 2017 out of the federal trial court in Manhattan, Hossein Zada versus Klein. So in that case, the plaintiff sued the defendants for making a reaction YouTube video, and the plaintiff's video consisted of a sketch. So it's not a music case, but attorneys and judges will look to similar types of cases, especially when there's not one directly on point. So in the Klein case, the defendant's video, which was about 14 minutes long, criticized the plaintiff's video. The plaintiff's video was 5 minutes and 24 seconds, and the defendants throughout their video played in the aggregate about 3 minutes and 24 seconds of the plaintiff's video. So the defendants would play short segments of the plaintiff's video, stop it, make comments. In the aggregate, they wound up playing the majority of the video. So the court found that this was quintessential commentary and criticism, and the court also emphasized that the defendant's video would not be a substitute for watching the plaintiff's video. I want to caution, though, that there are times when something is not fair use, even though it would not be a substitute for the original. And that's usually the situation where there would be an expectation that one would pay a license for the use. A couple of differences I want to point out. One is that, yes, in the Klein video, they're critical of the original, whereas Rick at times comes off like a super fanboy. However, Rick is teaching. And also in the Klein case, I assume that the defendant's video was monetized and they would have earned ad revenue from it. However, the court doesn't address that at all or talk about that. And if Rick were to fight back, his videos would be monetized, he'd earn ad revenue. And also, Rick tends to advertise at the end of his videos his courses that he offers for sale and his Beato book. However, a work can be for a commercial purpose and still constitute fair use. It's just more difficult to do so. That said, if I were advising Rick, which I most certainly am not in this video, hypothetically suggest to him that if he were going to fight back on one of his What Makes This Great Song Great videos, not plug anything in the video. I don't think you should look at one of his videos as something like using a song in a commercial, which of course there is an expectation of paying for a license. Again, it's just a quick plug at the end of the video where he's not using the song. All right, so the case that Rick would need to be careful of is one that involves an Elvis Presley documentary that used a large number of clips from a large number of Elvis's television performances. So in that case, the Ninth Circuit, over a blistering dissent, affirmed a preliminary injunction stopping the sale and distribution of the documentary. So Ninth Circuit did find that some of the use of clips likely did constitute fair use because it was using it as part of the historical record to discuss and comment on Elvis. However, the Ninth Circuit did not like a few things. One was that there were lengthy clips, at least one of which was over a minute, where there was no commentary. Sometimes they'd be playing a clip from one of his TV performances and commenting on something else. And in the advertising on the box for the documentary was that every one of Elvis's TV and movie appearances were represented in the documentary. So the court emphasized that essentially the documentary was advertising and then did seem to use the television appearance clips for their entertainment value. So I think in light of the Elvis case that Rick is still okay. I still think that What Makes This Song Great videos probably are fair use. And it's hard to imagine him being able to break down the elements of a song, the chords of a song, the sound of a song without playing part of it. That said, he needs to be careful that he doesn't give the appearance that he's playing a part of the song just gratuitously. For example, I watched one video where he analyzed the song Limelight by Rush as preparation for this, and there were one or two times when he was playing along with the song for a while that I thought, I don't really see the clear purpose of him doing this for the educational purpose. That said, I still think he would be okay. That said, I'd like to see people like Rick Beato fighting back more, risking a lawsuit, because if they win, so that way, number one, they're not getting bullied as much in the long run, and two, we need some case law on this. We need some more case law. So hopefully, me as being in a unique position as being an attorney who focuses a lot on copyright and internet law, and a musician. Yes, I might be a bad musician, but I still have, I know about music. So hopefully you like and subscribe and join me on this journey, especially if you made it this far. I'm impressed. I'm proud of you. This was a pretty dense one. I'll try to make some lighter ones. So take care.